King vs. Facebook, Incorporated. Counsel, please come 5 forward and state your appearances. 16 So Mr. King, what I want to focus on is the Communication 17 Decency Act. 2 So I'm really focused on Section 230, c. 1. My 3 understanding of your cases or your argument that you 4 seek to hold Facebook liable for discrimination based on 5 language, national origin, and political view. And that as a 6 result, the CDA doesn't apply. 7 And it seems to me that those claims would flow directly 8 from the posts that Facebook removed, which makes it similar to 9 all those other cases in this district, the Britain, Ibid, 10 Lancaster, Carrick's-Yawley, seeks for justice. 11 So if I followed my question for you will be, if I 12 followed the analysis in those cases, how would you distinguish 13 years from them? That's my central issue. 14 Now, what kind of procedural issues are you interested in? 15 Mr. King, there was a pending motion for in light 16 of my overall argument. Pardon me, Your Honor, there was a 17 pending motion for judicial notice of the USA Today story 18 which focused on this very issue. 19 And that matter was I agreed with counsel that it would 20 be addressed, at this stage, before the court. But 21 that was a pending request. 22 The court, so I read everything, but what I'm 23 really interested in is the law here. And those 24 cases would seem to, if I follow them, require dismissal of 25 your case. 41 So take on those cases, if you would. 2 Mr. King, I shall. Just real briefly, I do want to 3 pay homage to my mother, who is here with us, indicating. 4 And also for Justice John Paul Stevens, just left us. I think 5 They were both pioneers. I remember want to take that moment. 6 And do that. 7 The court, okay. 8 Mr. King, yes. Now, moving to your direct question, 9 Your Honor, I have my contention is that this follows the 10-na paragraph that I set forward, where the same course of 11 conduct can provide rise for multiple claims. That's nothing 12 new in the field of lawyering. 13 And Darna said, certain claims should be looked 14 at as a contractual analysis. And that is what their own 15 amicus counsel said. 16 Not only did their own amicus counsel say that the law has 17 been misconstrued for some time, I've compiled a list. I've 18 read all the pleadings in all of these cases from all the 19 counsel. None of them came with these issues of social 20 concern. 21 This case can't be developed in an envelope. The 22 envelope is too broad for that. It didn't happen in a vacuum. 23 And so we have before us the Darna case. We have their own 24 amicus counsel, David Luckmeyer, in accord. We have Seattle 25 attorney J.P. Dyer reached the same analysis in his law review. 5-1 There is a Hastings law review which reached the same 2 analysis, that the law is being misconstrued. And Hastings is 3 right here. I could throw a rock and hit it? And 4 That's one of the best law schools in the country. 5 We have the director of IBM saying that the law is not 6 being applied properly, and needs to be filtered a different 7 way, analyzed differently, to keep the context to keep 8 ascribed with the enormous political, and social realities that 9 we have here. 10 We have the NAACP boycott. Unprecedented. We have the 11 different media groups that came out against Facebook, and 12 compelled them to do a civil rights audit, which still is 13 incomplete with respect to discrimination on the platform a 14-year later. 15 So what we're looking at here, and there are also 16 actions that Facebook took, in analyzing my requests. 17 for review, like, letting them sit for 2 weeks at a time. I 18 think those things are also breaches of contract. 19 Obviously I think I have showed the court 20 recently where there's a white woman sitting there, and you 21 know, according to their own purported contract, in terms of 22 service, you are allowed to self-referentially refer to 23 yourself in a protected class that way. 24 So why am I not allowed to say that I was being treated 25 like a nigger, when I've got this white woman calling herself 6'1" cracker trash? And that's okay. 2 Now, common sense has been stood upon its head. 3 And this act was created to protect the fledgling Internet 4 industry, 25 years ago. May 5 I submit to the court, Your Honor, with all due respect, Mark Zuckerberg's worth $85 billion now. He's not 7 part of any fledgling Internet industry. He does not need aid protection from anybody. 9 We need protection from Facebook. And that's what 10 everyone is saying. Federal legislators. These legal 11 commenters are saying that the statute is being misapplied, and 12 that the same course of conduct may, under certain 13 circumstances, give rise to a contractual or civil rights 14 claim. 15 The court, okay. So I think I do understand 16 that argument. And I'm going to ask Facebook to respond to it 17 in a sector 18 but just so that I'm clear, what you're saying is that my 19 esteemed colleagues in the cases that I just said 20 out just have it wrong in the way that the CDA should be 21 applied, because it's being applied far too broadly, 22 particularly when claims of the nature that you're bringing are 23 being brought. 24 Mr. King, yes. I think and that's exactly what 25 Attorney Luckmeyer is saying. He's written briefs for 7-1 Facebook. Okay, he's no foe of Facebook, he's 2 that's what all these other scholars have said, including 3 Hastings Law Review. 4 And again, this does not arise the thing was crafted 5 with an eye toward protecting children from the with an eye 6 toward protecting children, and defamatory contact. 7 I think I cited a case also recently, though, that I'll pull up for you in a moment, where it was a California case 9 last year, where it addressed the fact that, hey, this is a 10 defamatory issue. Okay. That's not at play in this issue, in 11 this case. And I think they've gotten away with it for far too 12 long. And everybody knows that we need to curtail the CDA 13 the DCA in this matter. 14 And of course my question and my point to you is that, 15 you've got a unique opportunity, with everything that 16 I brought to this case, to start making a difference without 17 engaging in unwarranted judicial activism. There's a certain 18 thing of common sense. We can see that this is not what the 19 Act was designed to prevent to address, rather. 20 So at this point we come back from Facebook's comment. 21 In sum, if you look at a thing like their hate speech 22 guidelines, I clearly have not violated them. Anyone can see 23 that. 24 But, if Facebook gets to put out this type of purported 25 contract, and laugh at all of us while making billions off of 8-1 our backs, what we have here is a completely illusory contract. 2 And we have to go back to basic terms of statutory 3 construction that you learned in law school. Congress did not intend for an absurd result to occur. But it's absurd what's 5 and going on here. 6 So Facebook basically can say nanny nanny boo boo to all 7 of us, disregard whatever its policies allegedly are, and we have no recourse. 9 The court, okay. I understand your argument. 10 So how do you respond? 11 Mr. Thole, thank you, Your Honor. A couple of 12 points. 13 First, with respect to the Communications Decency Act, 14 We've cited a number of cases in our briefs, dismissing the 15 claims, all of the claims the theories of liability under 16 which Mr. King has brought his complaint, under CDA immunity. 17 The law, if you look at it, and if you look at the cases 18 in this district, the court is to look at the crux of the 19 allegations, not the name of the cause of action. And if you 20 look at the crux of the allegations in this case on page 9 and 2110 of Mr. King's complaint, all of the allegations specific to 22 Mr. King are about posts he made on the Facebook platform. And 23 That's really the complaint in this case. 24. This case falls squarely within the type of cases that 25 Your Honor listed in this district when these kinds of claims 9-1 have been dismissed under the Communications Decency Act 2 immunity, under 230, c. 1. Squarely within Ninth Circuit 3 precedent under the Barnes case. And Mr. King has acknowledged, in fact, that that's what the weight of authority 5 says. 6. With respect to the Darna case that Mr. King mentioned, 7. That is somewhat of an outlier in this district. And it's an 8 outlier in with regards to Ninth Circuit precedent. We've 9 cited other cases where claims for breach of contract and 10 breach of good faith and fair dealing obligations have been 11 dismissed under the Communications Decency Act immunity, where 12 they seek similar types of relief for the factual allegations 13 here. 14. And if I may, Your Honor, I just would like to be heard on 15 one final issue. 16. The court, 17. Mr. Thole, and that's our request that the complaint 18 be dismissed with prejudice. 19. And I just would like to state, Your Honor, Mr. King is 20. This is his third version of the complaint he's filed here in 21 this case, in this district. He filed another case earlier in 22 the state of Washington, alleging almost identical factual 23 allegations. So he's had a number of opportunities to allege 24 all the whole universe of facts that support or that he 25 believes support his claims for relief. 10-1 and so, if the court agrees that dismissal is too warranted under the Communications Decency Act, leave to amend 3 would be futile, Your Honor. 4. The court, and so yeah, let's on that point, 5. Mr. King, and then I'll give you a last word 6. Mr. King, 7. The court, it seems to me that however your claims 8 are alleged, they all arise from the posts. And what 9 Facebook did with respect to the posts. 10. And so I'm wondering whether you think there are facts 11 that you could allege in addition to that, if I ended up 12 sticking with the analysis of those other cases in the Northern 13 District, whether there are any facts that you could 14 allege that you think would make your claim 15 survive. 16. Mr. King, there are several holdings, Your Honor. 17. And the first is the Seattle case never heard anything on the 18 merits. That was strict. 19. The court, well, just focus I actually don't care 20 about those cases. 21. Mr. King, okay. 22. The court, I only care about whether you 23 think that you have additional things that you could allege. 24. That would avoid the sort of preclusive analyses of those 25 cases that I mentioned, if that's where I end up going. 11-1 That's what I'm wondering. 2. Mr. King, 2 things to that, Your Honor, briefly. 3. First of all, as the Hastings article by Joey OU suggests in 2013, the bad faith exception which generally goes to 5, c. 2, the overriding presence of clear-cut bad faith must 6 overshadow all of it. Because, again, Congress does not intend 7 for an absurd result. 8. For a global monolith to act in complete bad 9 faith subverts the entire reason for the policy in the first 10 place. Ab initio. They can't continue to do 11 that, and laugh at the rest of us. That's part of it. 12 But yes, I do believe that looking further into this, that 13 I could narrow it a little bit. And I'm still not releasing 14 any of my pending arguments, either. 15 But I do think that this is a matter of social 16 significance, the defendant tries to ignore it. But no, I just 17 rattled off all these organizations. This is an unprecedented 18 groundswell of support as for my position right now. 19. The court, yeah. So I hear that argument, but I'm 20 asking a much narrower question, which is, are there facts 21 arising from the way that Facebook treated you that you 22 that you can allege that are in addition to 23 what you've already alleged, that would address the 24 problem that I see with 230, c. 1. 25 Mr. King, well, what I can do and I think this 12-1 would be quite relevant is to flesh out the point that 2 Facebook's treatment of me is retaliatory breach, as opposed 3 to the specific content in hand. Just the way that they process my claims and the way they are treating me is 5. The court, arising from the things that you've 6 already alleged. 7. King, right. But there's a process at hand. 8. And the way that they've gone about their processes, I can 9 show that it is not truly something they're doing out of 10 concern for what I posted. 11. For example, get this. Here's the kicker. I 12 have many blogs, but 2 blogs are at issue right here. I have 13, one called, How to Sue Facebook, Blogspot, and Chris King's 14 First Amendment page. 15. Chris King's First Amendment page has been up for 16 years. Since my mom recommended I start blogging. Okay. 17. Before it was even fashionable. I've been linking that to 18 Facebook ever since I was a member of Facebook. 19 since 06, I think. 20 then, last year, when I filed the suit earlier this year. 21 I created How to Sue Facebook. Everything that's in How to Sue 22 Facebook is on Chris King's First Amendment page, indicating. 23 But not everything here is here, of course, indicating. Okay. 24 So after I called out the fact that Facebook was 25 blocking both of these, indicating, Facebook comes up, and now 13 they allow me to post Chris King's First Amendment page links, too, but not How to Sue Facebook links. So it's not the content. 3 It's retaliation. 4 The court, alright. So, thank you for your 5 argument. I will look at this again when I get off the bench. 6 And I will get an order out as soon as I can. 7 King, thank you, Your Honor. 8 The court, thank you very much. 9 Thole, thank you. 10 Proceedings concluded,